You've heard about the Greece decision earlier today, and we are fighting back. And at FFRF, we think that it is essential to honor the path blazers and activists and litigants who work to protect the First Amendment so it can protect all of us. And we are honored to have at our conference the two women litigants who so correctly and steadfastly protested their local government's improper practice of holding almost uniformly Christian prayers to open public governmental meetings that are meant to be inclusive and not exclusive. Linda Stephens, who was an early complainant, was joined by Susan Galloway, and they won a resounding victory at the Second Circuit Court of Appeals, only to have their own town council contract with the theocratic group, the Alliance Defending Freedom, to challenge their victory and appeal to our Supreme Court. And Susan and Linda are heroes or heroines. They have endured a lot of pain and opprobrium in their small town. And as I said, I could feel the hostility and how uncomfortable it was even for me as an outsider to sit there facing the town that said the majority rules over matters of conscience and religion. So this was a very personal as well as a legal battle. And we are so proud to name both, you can both come up, I think, Susan and Galloway and Linda Stephens as FFRF's Freethinkers of the Year. While she does that, I wanted to say that our first Freethinker of the Year was Ishmael Jaffrey, who brought and won a case against religion in the schools at the Supreme Court level in 1986. And we used to be able to win Supreme Court decisions. Do you remember that? And we feel that the law will be corrected, and reason and secularism will once again prevail. Someday, if the Free Thought Movement does not give up and takes a page from Linda and Susan. And again, I want to report very reassuringly that FFRF's brief lawsuit here in California in state court in Pismo Beach entirely ended prayer this year, this spring. So there is hope. And first, I'm going to introduce Susan Galloway. And she's a graduate of the University of Illinois Urbana-Champaign, who's worked mostly in long-term care, including helping people with Alzheimer's. She's a social justice activist and first advocated for separation between church and state when, as a fifth grader, she refused to sing in her school's Christmas concert.
Can you see me? Thank you. Thank you for this award. Thank you for the amazing greeting. I've never been in a room with so many people who believe in separation of church and state and are willing to fight for it. I got involved with this. I started attending the meetings at this particular time over a public cable access channel. And I continued to go to the meetings to fight for public cable access and its continuation. And I noticed a pattern of the prayers, and they were all quite sectarian and all Christian, and it made me feel uncomfortable, and it made me feel like I didn't belong in a town I should have felt. You know, when you're in government, it should feel inclusive, and it sure didn't feel that way to me. And as I was looking at this podium, I was imagining the fact that this is kind of how it was at the town board meeting. Instead of freedom from religion, though, it had the big seal of the town of Greece. And of course, the pastors, I'd be out there with you, and they'd be saying their prayer and, asking Jesus and all the other trinities and whatever. It depended on the pastor, and asking them for the town for wisdom and make good decisions, and it's hard to believe that the Supreme Court would have thought that it was directed at the board members when they would have been behind here, and the pastors was facing me and Linda and whoever else was in the audience. And then, of course, they'd be crossing themselves, and the board members would be crossing themselves, and it just was very uncomfortable. And I thought it was very inappropriate. And I said, this is not okay. And Linda and I had known each other through other activist work, and we said, let's do something about it. And I had hoped that we could solve it by talking to them reasonably, reason, hey, this is uncomfortable, this is wrong. It didn't happen that way. So we ended up filing a lawsuit. And as it turned out, an ordinary person who spoke up had an extraordinary thing happen to him. And that was, it went through the courts, and it ended up at the Supreme Court of the United States. We lost in the district court, and we appealed it. And in between the district court, we discussed do we want to appeal it, because we knew it would go up to the Supreme Court. And if we won, they would appeal it up to the Supreme Court. But at that time, we didn't think that it was likely that it would be accepted. And so we appealed it, and we won in the appellate court. And as it turned out, there were other cases that were pending in other appeals courts throughout the country. And with timing of their decisions and everything, the courts were split, and the Supreme Court decided to take our case. Now, if you're not familiar with our brief, we had videos. The same institution that I was fighting to save had, from the beginning of the prayer practice through when the evidence was closed, all the prayers that had been done. So we had videos of almost 12 years of prayers. So there was no denying what had happened. There was no denying, how it looked, how they stood, everything. So it really came down to our argument of the fact that it violated the First Amendment because town of Greece aligned itself with religion. And unfortunately, the Supreme Court and its makeup decided that it was tradition and that was what was right. And we lost in a 5-4. But I do think that it was very interesting that the 3 justices of a minority religion all dissented. So I think that was a good something that was good about it. But I want to tell you, since what's happened since. On August 15th, the town adopted a new invocation policy, which was almost identical to the Alliance Defending Freedom's model prayer policy. And I'm sure you all know Alliance Defending Freedom. They represented the town of Greece in the lawsuit. And this policy, when I went to the town board meeting, And I saw on the agenda that they were going to have this prayer policy and vote on it. And I asked them for a copy of it. They didn't have a copy of it, so I had no idea what it was in it. And they basically voted on it unanimously, no discussion, passed. So the next day I went and I got the prayer policy and I read it. And they basically contradicted everything that they said in the Supreme Court. They had said in the court that anybody was welcome to do the prayer, that they didn't discriminate, that they didn't, and that there were no restrictions. But in this new invocation policy, you have to have a representative from an assembly that has a 501c3 tax-exempt status. And that this policy, as I said, was approved without an opportunity for any public comment. There were no copies, no nothing available to the public before they voted on it to comment on it. And what was interesting was that in the 12 years of videotapes and prayers that they had had 3 token prayer givers. Right about the time we were filing the lawsuit and right after. And, it was obvious they did it because they wanted to have the evidence that they were allowed anybody to do it. And what happened was this prayer policy now will totally eliminate the ability of people, of 2 of the 3 people, from ever doing the prayer again. And it really was a bait and switch. They said, this is what we do, and then after the cameras and the media and all the attention was gone, they, just passed this terrible bill. And it's terrible, and I continue to fight it. It was interesting, it was passed in August, and in September, I stood up and I complained about the policy. I complained about the way it was handled and putting it out there. And the supervisor, when I was leaving after my comments, made some very insulting response. He said, "The hypocrisy. We won the lawsuit. We are allowing atheists to come and pray because they want us to be tolerant. But they're not tolerant of Christians." The hypocrisy. And to say that the town is merely allowing atheists, when they say they don't discriminate and anybody is welcome, was just totally, I can't tell you how angry I was. In fact, I responded, and he told me if I wasn't quiet, he'd remove me. But it was just this pompousness that they have the right to do this, and the hell with anybody else and what they believe and what is right. They're going to do what they want to do. And I can't emphasize the importance of separation of church and state, and I think people don't really understand it in the general public. They think, what's the big deal? Just don't listen. Or, you can, just think about something else or whatever, but it's not that big a deal, but it is. It is when you are made to feel like a second-class citizen at a government meeting, when you are supposed to be part of that community. And then after like when they ask people to stand and you don't stand, and you're supposed to be able to go up there and ask them, hey, I would like you to not get rid of our public cable access channel. Is that going to affect how they vote and how they respond to me? And I can't believe that it's not going to have an effect. And when the justices say adults can't be coerced, well, need I say anything more? Look at how many people just do things because other people are doing it or peer pressure, they just want to belong. It happens. And the whole case, I swear, we had a great case, but we had a lousy court. And I hope that a future case will come about and this terrible decision will be overturned. And I hope it's in my lifetime because we can't wait. And I just want to thank you again, and thank you so much, and I'll say this, because I felt very alone a lot of times, and I'm grateful that I went through, that Linda and I went through this together. But the support, I swear, I didn't feel it. And it's so wonderful to see so many people who truly believe this way, because sometimes it gets really lonely and you feel like you're fighting a battle by yourself. And I am so glad, and I'm thankful that you guys appreciate this, and thank you so much for this honor.
There we go. So Linda Stephens is not only a member of the Freedom from Religion Foundation, but shortly after the Greece decision was handed down, she became a lifetime member. So thank you, Linda. And she hails from Greece, New York, she lives there now. And she has a master's in English and library science, a doctorate from Syracuse. Linda worked as a librarian until she retired. Linda was known as the Atheist Plaintiff in the Greece case. She's an event organizer for the atheist community of Rochester and vice president and web administrator for the Rochester chapter of Americans United for Separation of Church and State, which nationally took the Greece case. Linda Stephens is also past president of the Greater Rochester chapter of the National Organization for Women, so we have a great activist here. Please welcome Linda Stephens.
I'm going to preface my remarks by telling you one thing that I learned going through this experience. Lawsuits can be very messy, and unexpected things can happen. That's the two things that I learned. Good evening. I'd like to thank Annie, Lori, and Dan and FFRF for this award. I'm a longtime admirer of this organization, so this is a real honor. So I'm Linda Stephens, the atheist plaintiff in the Town of Greece prayer case. The plaintiff, who you may have heard, got thrown under the bus at the Supreme Court. Here's how it all began. In 2002, I belonged to a group called People for Parks. It's a parks advocacy group. At that time, People for Parks had some issues with the Greece town supervisor. And that's when I started attending town board meetings and first became aware that the new supervisor had begun opening meetings with prayers exclusively delivered exclusively by conservative Christian pastors. Naturally, I thought this was wrong, but I just grumbled about it and did nothing. Then, over time, I became aware of other inappropriate things that the supervisor was doing with local churches. He began hosting prayer services in the town hall every January and started giving one of the local churches government money to put on its 4th of July celebration. Then I eventually learned that there was a local chapter of Americans United for Separation of Church and State in Rochester. So I ended up joining that group, got on their board, and I started getting AU's monthly newsletters. and I began reading about a lawsuit that Americans United was involved in Forsyth County, North Carolina. It involved a situation very similar to what was going on in Greece, New York. The local government was opening its meetings with Christian prayers, and the issue was being challenged in federal court by Americans United and the ACLU. That's what prompted me to speak with AU's legal director in Washington about the situation in Greece. AU took an immediate interest in the case, or in the situation. So during my initial conversation with AU's legal director, she asked if I knew of any other Greece residents who objected to these prayers. I put her in touch with Susan Galloway. Susan and I had both been active in the local chapter of NOW, the National Organization for Women, and I knew Susan's views on this subject. So the first thing that happened, Susan and I met with town officials and asked them to stop the prayers. The deputy supervisor told us no, they couldn't do that. And the reason given was if they stopped the prayers, it would offend the pastors. Next, the legal staff at Americans United tried to reason with the town. They wrote a letter to the town supervisor telling him the prayers were a violation of the First Amendment and explaining why. The supervisor ignored the letter. AU then went ahead and filed a lawsuit in District Federal Court in Rochester in February of '08 on behalf of myself and Susan. The AU lawyers wanted to use the same argument that they and the ACLU were successfully using in the Forsyth County case. That is, they wanted the district court to rule that Greece was violating the First Amendment because the prayers being delivered in Greece were almost exclusively sectarian. Just to be clear, AU was not arguing that the prayers in Greece should be stopped altogether. Instead, the lawyers were arguing that in order to be in compliance with the First Amendment, these prayers would have to be non-sectarian. Like Susan and myself, the AU lawyers would have preferred to ask the court to declare all prayers before the Greece Town Board unconstitutional, but there was a problem with that. In 1983, in the Marsh v. Chambers decision, the Supreme Court had ruled that prayers before government meetings were legal so long as the prayers were non-sectarian, that is, so long as the prayer givers were delivering their prayers to a generic God without bringing up specifics of particular religions, such as Jesus. So you may wonder why I, an atheist, was willing to go along with this argument. My thinking at the time was this: the overwhelming number of pastors who delivered prayers at the Greece Town Board meetings had made it clear in the paper and elsewhere that they could never deliver non-sectarian prayers, that they were compelled by their religion to pray to Jesus. So I thought to myself, if the court buys the non-sectarian prayer argument, most of the supervisor's pastors will bow out, and that will end the prayer business in Greece. Problem solved. Well, things went awry with that plan right off the bat when the AU lawyers went to the district court in Rochester. Judge Saragusa, a Bill Clinton appointee, didn't buy the non-sectarian prayer argument, so we lost the case in the district court. Next, the AU lawyers asked the Second Court of Appeals in New York City to reverse the district court's decision. Even though the non-sectarian prayer argument fell flat at the district court, the AU lawyers went with that same argument at the appeals court. A 3-judge panel at the appeals court did rule in our favor. They decided that the town of Greece had violated the Establishment Clause by having a steady drumbeat of Christian prayers at its board meetings, and for several other reasons. However, the appeals court did not like AU's non-sectarian prayer argument. As Judge Calabrese wrote in the decision, as Judge Calabrese, who wrote the decision, has explained, requiring non-sectarian prayers would be in itself an establishment of religion, an establishment of the okay religions, the religions that are sufficiently acceptable. And as Judge Calabrese also pointed out, the problem with non-sectarian prayers is that they leave out secularists and, of course, people of minority faiths who pray to multiple gods. So after losing their case at the Court of Appeals, the town and their Alliance Defending Freedom lawyers appealed to the Supreme Court. The Americans United lawyers were a little nervous about that, but not real worried, because the Supreme Court gets about 7,000 or 8,000 requests to hear cases each year, and they only take about 80 of those. So the AU lawyers thought the odds were slim that our case would make it to the Supreme Court. But as Susan mentioned, the Greece prayer case had one thing going against it. Similar cases were being litigated all over the country, and the lower courts were coming down on different sides of the issue. Some courts were buying the non-sectarian prayer argument, and others weren't. And when such a situation occurs where lower courts are in disagreement, then the Supreme Court is more likely to step in. And that is exactly what happened with the Greece prayer case. Now our lawyers started getting very nervous. They knew what kind of Supreme Court they were up against. They also suspected that atheists and the rights of atheists were not high priority items for justices on the court. Justice Scalia, for example, just recently gave a widely reported speech in which he said that it was, quote, utterly absurd to say that the Constitution cannot favor religion over non-religion. But the AU lawyers had no choice but to forge ahead, and they stuck with the same argument that had failed at the district level and at the appeals court level. They decided to go ahead with the non-sectarian prayer argument and soft-pedal much mention of atheists. Now, by this time, I had become less than enchanted with the non-sectarian prayer argument, particularly after what the Court of Appeals as well as the district court had said about it. So Susan and I and the head of the AU legal department had a conference call about this, and I brought up my concerns. But at this point, the legal staff was insistent. They said they couldn't switch horses in the middle of the stream. They wanted to stick with the non-sectarian prayer argument. So now I started worrying about what our lawyer would say if one of the Supreme Court justices asked why an atheist would want non-sectarian prayer. But our lawyer told me not to worry. If that question were asked, she said, she would give a layered response. Well, it turns out our lawyer didn't have a chance to give a layered response. At the last minute, the AU legal staff decided they would have Douglas Laycock, a law professor from the University of Virginia, argue the case instead of the AU lawyer who was supposed to do it. So comes the day of the oral arguments. Susan and I meet Douglas Laycock for the first time. During the oral arguments, the issue does come up about whether non-sectarian prayers would exclude certain people. Chief Justice Roberts comes right out during this exchange and says to Professor Laycock, "We've excluded the atheists, right?" And how does Professor Laycock respond? Astonishingly, he agrees with Justice Roberts. So I'm sitting there listening to this and wanting to sink under my seat. Professor Laycock, it appeared, had forgotten that one of his clients was an atheist, and the AU lawyers had apparently forgotten to remind him to give a layered response to any such question. So we get outside the courthouse after the oral arguments and are stuck in front of the TV cameras, and all I can think of to say is, atheists need to come out of the closet like the gay community. And then, of course, the reporters and the bloggers go to work writing about what happened at the Supreme Court. The headline in The Economist was, "Atheists Thrown Under the Bus." Dahlia Lithwick, who reports on the Supreme Court for Slate magazine, tells an audience at a conference the same thing. And this was the big story. And I am told that the AU lawyers came in for some immediate heat, particularly from the atheist Twitter community, who barraged them with tweets, the basic theme of which was, WTF, what the fuck? Ron Lindsay, the president of the Center for Inquiry, wrote a blistering piece about this on the CFI website, titled, "We've Excluded the Atheists, Right?" In the article, he repeats that Professor Laycock threw atheists under the bus, and he brings up the fact that the Establishment Clause was intended to protect minority rights, not the sentiments of the majority. In that same piece, Lindsay also suggests a layered response to Justice Roberts' question. This is in part what Lindsay says Professor Laycock should have said in response to Justice Roberts' question. He says Laycock should have begun by saying that we all recognize that the court is not going to overturn the Marsh decision and outlaw prayer before government meetings. Then he went on to say, if this court is going to allow prayer, it's clear that if we want everyone to feel part of the political community, there are certain things that must happen. One of which is that opportunities to open the business meeting must be offered to all, including to non-believers who are willing to deliver a solemn secular opening. Do you have any water? And of course, we all know the outcome of the Supreme Court case. The court did not buy the non-sectarian prayer argument. Instead, the court said sectarian prayers are fine. Go ahead, guys, pray to Jesus all you want. Pray to Jesus all you want. However, the court's ruling did include one positive thing. It said that if municipalities have prayers before meetings, they cannot bar non-Christians from delivering them. So right after the court decision came down, atheists and other secularists jumped on this and ran with it. They began delivering invocations at local government meetings all over the country, even in places like Huntsville, Alabama. In July, Dan Courtney delivered his atheist invocation at a Greasetown board meeting where over 100 atheists and supporters showed up, along with a lone protester with a Jesus sign who refused to give his name to a reporter. So this brings me to the present. Susan talked about the town's new prayer policy. According to that policy, it appears that atheists might be allowed to deliver invocations at Greasetown board meetings, but only if they meet certain requirements. Whether the new policy is just a ruse to keep atheists out is still unknown. So in the meantime, myself and other local atheists are getting our ducks in order. We have requested that Sunday Assembly Rochester, which is the new atheist church in Rochester, and the atheist community of Rochester both be allowed to participate in the delivery of invocations. And what is my final assessment of the Supreme Court decision? I'm glad the court did not buy the non-sectarian prayer argument. I also think this whole thing has been good for atheists in one big way. It has helped raise the profile of atheists and other secularists in positive ways all across the country. Locally in Greece, it's interesting to see what's been happening at the monthly town board meetings lately. At the last two meetings, when the supervisor called on the designated Christian pastor to deliver the prayer for the evening, the pastors were nowhere to be found. They simply did not show up, and there was no explanation for their absence. There has been speculation about why this is happening. It could be that the pastors don't like the thought of sharing the stage with atheists. It could also be they don't like giving prayers that are now limited to 1 or 2 minutes at most. This is a new rule since the lawsuit. And in the past, some of the pastors have given prayer. I should note that many of the prayers that were given prior to this went on and on and on. And it could, and the pastors may also be upset because they aren't able to deliver their prayers to the audience anymore. Now the podium faces the town board members. It does not face the audience. So they are unable to give these long prayers and proselytize to the average citizen. So the final thing I would say is that the Greece prayer decision did not lay this issue to rest. There will likely be more litigation, and one day the Supreme Court may have to decide whether Judge Scalia is right when he says that the Constitution can favor religion over non-religion, and therefore bar atheists from delivering invocations before government meetings. That issue was not settled definitively in this court case. Thank you. Thank you.